Haverhill on Clark versus Jeffrey Thompson. Did you get that in the letter?
Mr. Thompson is not checked in.
No, he's here. He's here.
Good morning. My name is Edward Long. I'm an AHL 715.
All right.
I'm here for the plaintiff this morning.
All right. Very good. Mr. Thompson, can you state your name, please, sir? All right. Very good. And who's here with you? We don't want anybody left out.
Actually, is here. She's the manager of the facility.
All right. Fantastic. All right. And where are we, folks, on this case?
Still position of the facility that they would like possession of this unit.
All right.
What else I can do?
Well, you need to speak up.
We haven't done everything I can. Just well,
Go ahead, Miss. Hang on a second, okay? Take your time and just tell me what. Go ahead. What were you saying?
worked really hard to get my family out. I think back to CMH, like I have a 3-hour session with them today. I feel really good about myself. First time in a long time. It's just that I've been through a lot. And it's not an excuse. My dad died, and I keep my unit up. I mean, I get along really well with neighbors. My aunt just passed 2 nights ago.
Have you did plaintiff get any medical records or medical documentation?
We received a letter from a medical professional at the last hearing saying that he was under care. Was under his care. It's Dr. Stilger.
Yes.
But there have been multiple incidents of erratic behavior and damage to the facility caused by this tenant. And
Since the time of being in court and coming here?
since the time that this action was filed, yes, but his tendency was.
Well, I want to make sure I'm clear on that. From the time you filed, have other incidents occurred?
Yes. Since we filed.
Yeah, so there were 2 incidents since we filed.
Okay, what were the nature of those?
One incident, there was damage to the building and there was blood left in the hallways. And then the second incident, I was found in the middle of the street.
Pardon?
The second incident, he was found in the middle of the outside, half dressed by the police.
I was not half dressed. I was they told me that when I got to the hospital. That's not true. Montgomery was actually stated by people in the facility of the defendant being in the street.
Pardon?
There are residents of the facility who have took pictures of him in the street. Wasn't naked. I wasn't half dressed. They told me I had my clothes on.
T-shirts, boxer shorts, socks, t-shirt.
Underwear, basically. No, it was shorts. They were some. It's being criticized.
I'm sorry.
I didn't think I needed to do it in the hospital. I'm getting treatment and just feeling. I mean, have things stolen from me at the property, and I keep it in place to get along really well with the neighbors. My neighbors really like me.
Let me ask you this, Mr. Thompson. We kind of went through this the last time. At the point in time, well, what I was hoping to get and what we had indicated to counsel. Were you able to, if you remember this, what we were trying to do was to show or at least give some indication that something was happening with you at the time of these incidents. Remember that?
It was, and
Pardon?
it was, I wasn't on medication at the time, they just introduced medication, so. I've been on the regimen now, we'll go back to review next week. I met with the psychiatrist last week again, and he said that he would come in and talk to you if he needed to, but there was a lot of bad things going on at that time, and
No, I know that's what you were indicating. And what we were trying to get was for at least plaintiff's consideration and maybe the court's consideration at some point in time. That there were certain issues regarding medication, right? And where you were actually, if I'm recalling correctly, you had indicated you were off medication.
yeah,
And then there was a series of things, and I'm just trying to recall off the top of my head the last time, correct me if I'm wrong, okay? That you had gotten yourself back on your medication,
yes.
understanding that was going to take some time to, in any event, settle into your system.
We're still tweaking that, that's what I have to go back.
Pardon?
We're still tweaking that regimen, that's what I have to go back for next week. But it's stabilized, it's, I feel really good, I feel really good about myself, so.
These other two incidents, what dates did they happen?
And I remember the exact dates. The most recent one was about a month ago. It was probably 2 days prior to the last court date. The court date didn't show up. And then we have the judgment granted, the default judgment. So a couple days before that missed court date, that's when the first sentence.
When he was hospitalized.
Yes.
And so the event, this is the one in the street, happened 2 days before that. That almost kind of makes sense because then we had the court date, he's hospitalized at that moment. And you don't have the date on the other.
The date on that date.
Pardon?
There hasn't been any problems since then.
No. Here's what I'm just trying to figure out. I'm trying to figure out the date that they're saying there was this other event. You follow that, Mr. Thompson? Okay. But we don't know that date.
It was in October.
So was it? Was it right around the time of, say, what would have been the first hearing in this case? You think so? Because if you're saying October,
Yes, I think.
and the first hearing was in October 17th is what I have. So it was right around that time, ma'am, you think? Okay. And at that time, you were not medicated.
No.
Okay, so let me ask you this. When did you first get medicated? Well, that's a stupid question. All right, so let me ask it this way. These events start occurring. There's a point in time where you're not medicated, right? Then at some point, you may have ended up in the hospital or talked to your, whatever it is. Then you begin they figure out that they're going to put you on some type of medication.
3 medications.
Gotcha. Okay, that's fine. And do you recall the time frame when that occurred?
I was at the hospital and shortly thereafter. When they introduced the medication. But I was off my meds before because I wasn't taking the first step, right? I decided to start a second step.
I got you. So, but you don't remember when that date was? No, it's okay. It's all right that you don't remember. I mean, I'm asking people dates and I can't remember yesterday. So, but you were, and then the Medicaid, and then, and again, sir, correct me if I'm wrong on this, okay? But as they give you the medication, they're probably telling you, warning you, and you also probably know your system's going to have to adjust to it. That there's not going to be these sort of miracle pills and all of a sudden everything's going to be okay. Right?
That's what the doctor said, that we have to tweak it as we go along.
Okay. What I'm trying to figure out is how far are you into, and the reason I was looking for the date is I was trying to figure out like how far you're into that process.
Since I told you about the beginning of November, it's like maybe 2 months now. Maybe.
Okay. All right. No, that's fine. So you've been on it 2 months.
See him again this coming week.
Pardon?
I see the doctor again this coming week. And then I have SKMH today, 3 hours.
Have you been down? I know we've kind of been through this process, but I don't know that you were in a, and I don't mean this badly, but you were in a state necessarily to follow all of the instructions the court was giving. Okay. Have you been down to talk to legal services?
Yes. Mr. Alex Henry sent me an email yesterday and asked me if I was doing okay.
Okay.
I haven't seen him recently.
Okay. Let me ask you this. And maybe you know, maybe you don't know the answer to this. Was he asking you that because of your connection to Arbor One or because you had called him in regard to this case? Do you know?
He's following up on both. He saw that my name was here with you today and our one, that's still, all that's still happening. I was still in the process with a different court now, and it's,
Pardon?
it's still active. It's with a different court. The Arbor One case, and so we have to still go to those hearings.
I know. There are actually now 3 courts involved, which is just a wonderful process.
It's a bad place.
Pardon?
That was a bad place.
I know. And you're still trying, from the whole situation you had with Arbor One, that's how you ended up here, right? That's what I recall. Pardon?
Latasha helped to get me here, along with the rest of the team. They've been really nice. It was a bad place. Bad place.
I know.
And we know some of it, but I wish you could have seen like just how bad it was. Stuart Beale is not a nice man.
Pardon?
Stuart Beale is not a nice man. All right.
No, it's okay. It's okay, Mr. Thompson. Maybe you don't know this, just as a side note. I was going to take, and I don't know if you had heard, I was going to do the extraordinary step because the tenants are telling me one thing. Management was telling me another thing, and usually I'll just listen and hear.
He's
See what I was
so
gonna
many
hear.
times he's lied. He just lies.
I know. Well, I don't know that. But the one thing they went to an extraordinary extreme to stop, I don't know if you knew this, is that I had prepared for all the security. I was going to go out there and see it myself.
Well,
And the day I was going to do that, everybody's positions start changing about things.
I'm so glad that you're able to help them. You know, they really do. Like, it's just a bad place. Not bad people. We're not bad people. We're good people. We're just people who had bad times.
As I see it, since I'm not I'm kind of involved in it, but with the cases that I've been able to look at, you were good people that were in deplorable conditions. Is that why you weren't taking your medication? Why'd you
I
stop?
was scared. I lost my dad. I just lost my aunt. My mom's not doing well. I'm on my own. I'm
Okay. The world just became overwhelming.
Yeah.
Okay. And while all that's going on, you just come out of, or we're still in the midst of this Arbor One thing.
Yeah.
Okay.
I'm not a bad person.
Yeah. You know something? And I'm going to say this. I know you're not a bad person
Thank you.
because I don't talk to bad people this long. Okay. I usually let him talk to him. I'll say a couple words, but then Mr. Allen takes over. Okay.
Okay.
All right. Did Mr. Henry say anything about that he would represent you? Yes.
They didn't have the resources. He said he would, but they didn't. The services didn't have the resources. I'm so stretched thin right now with everything else.
Did they refer you to anyone else like the Michigan Clinical Law or anything like that? This is set for F. This is set for final settlement today. All right. And so the complex isn't willing to do anything either in terms of a conditional order of dismissal or a probationary agreement. They're not willing to do anything. Is that what I'm hearing?
No,
Because if they're not, then I might as well just set it for trial and I'll just listen to everything and rule on it. Pardon?
they're not lying. They have given a valid notice to quit 30 days.
I understand the procedure, counsel. I'm just trying to figure out where they are in terms of any possible resolution in this case.
My discussion with my client today was that they want possession of property at this point. The other attorney that talked to me last time said that he was going to try and work with me.
I think it's possible, maybe.
Well, go ahead. What were you going to say?
Just have a voucher. If maybe we can give him some additional assistance, maybe like a living caregiver, someone who is there to help him through the process of what he's going through, because he really is a nice guy. We don't want to have to go through this process with him, but because of the threat to the community with the psychotic episodes and the damage to property, of course, ownership is pushing for eviction. But I did speak to the regional manager and she's willing to work out a resolution, but it has to be something where it's actually more than medication or maybe some extensive outpatient treatment. We want to see something to ensure that these episodes don't.
So how to do that? I'm doing that with
Hold on. Okay. So let me ask you this, Mr. Thompson. Right now, and I don't think we're saying anything that's in violation of what may be your privacy. So how, because you said it, you're seeing a psychiatrist now, right? Okay.
yeah, Dr. Stolzer, Dr. Timberland.
Okay. And you're on medication, right? And they're working you through that process of medication, right? Okay. And I just want to tell you, if I ask a question, and it's okay to do this to me, about your medical, and you don't want to tell me, you don't have to tell me. Okay. And I'm not gonna get mad. Okay. That doesn't mean I'll stop talking to you and you got to talk to Alan. You got me? Okay. All right. So, outside of that, have they put any other services in place for you?
I don't know. I don't think so.
Okay, that's fair. Have they said anything about I don't think it would necessarily be an outpatient type of thing, but have they talked about any other types of
I see my therapist once a week. If you remember Amy.
so you're on a once a week?
Yeah, Amy, I
Okay.
see Amy. She said that she's gonna send you a letter and then
Amy did?
Yeah.
Okay, I don't have that.
she said she sent it, I think 2 weeks ago. And then, Shet and Jamie at CMH are the people that Shet's the case manager at CMH. It's going on to see today. I would see them every Tuesday from 12:30 to 3.
So, okay, let me just follow here. Okay. You said a lot there. So every week you see your therapist
On Thursdays, yeah.
on Thursdays, and then you're with CMH. And how many times, what's your involvement with CMH on a weekly basis?
It's the men's trauma that they have me going through right now. I've been going through that the last couple of months.
Okay. So let me ask you this. Pardon?
Since our remote, they put me there.
Got it. Okay. And so that's been a couple of months that you've been in that. How's that working for you?
I love
Huh?
Jamie and Shet, creative. I love them. I really do. They're good people. They're really good people. You can say anything in there. There's something in there. Some nice stuff with whatever you're challenged with. And CMH is so great. I mean, they're just so. The people really try hard to help you, but yeah, I don't always understand what I do, like why I do it, but it's helped me to understand my behaviors and my patterns.
Got it. Let me ask you this.
So it helps.
When all of a sudden you're about to go in, and I'll call it crisis, something happens and you're about to go in. Let's say you leave here today, okay? And God forbid, but let's say all of a sudden that begins to occur for you. What are you going to do, you think?
The first person I can call is somebody at the crisis center, 734-577-3151. And
So you got it.
The last time I was in here, I called Kelsey. I called Kelsey right when I was in here because the other attorney wasn't very. He was pretty stern and really scared me at the point. I get nervous. So
No, I know.
Kelsey was so nice. She calmed me down and they wanted to make sure that I got there as soon as I left here.
So
They're always so nice to me, and they don't judge me. They don't try and criticize me. They do everything they can to try and help. And it's not an easy thing to talk about, but I love I can't speak. I have nothing about them. They're just so nice.
Okay. I wasn't aware of that, but one of the last times you were here, you had things kind of got to you. And so, but
I still get jumpy in the apartment from time to time, different sounds, just because of all the sounds they had in Latasha. We had to talk about it. The guy below me was beating up his girlfriend for the longest time, and the last time it was right out in the parking lot on the hood of his car. He's beating the hell out of him. His dogs were running around the car, and a guy came up the hall one time, and he had a knife that he was pushing into the wall, and I'm not.
so that all, hold on a second, but that causes some reaction for you. And so here's what I'm worried about. All of these things, and as I sit here as a judge, I wish I could control everything in the world. I can't. But all of these things are occurring around you, right? And there's something that happens with you. Much like with the attorney that you thought was being stern. He's probably just representing his client, but he's being stern with you. That
He said he's out there in the hallway, and he said that he thought that's a nice guy. He just wanted me to relax. He was nice after he scared the hell out of me before that.
attorneys do that. Okay. And Mr. Thompson, I'll say this. I mean, I have to rule how I have to rule, but I think you're a nice guy too.
Thanks, Judge Simpson.
All right. And so what we have to figure out, we have to figure out a way, if you're able to stay there, and it can be resolved in that fashion, of basically certain types of programming that's in place that you're going to continue on. Okay. That would give, and I can't guarantee that that's what their ultimate decision will be, but will give them the assurance that they're not going to have the issues that are caused by this. Okay.
I live on a really nice floor. The building gets quiet. And my neighbors are just great. They're really good people. Yeah. Two on the one side. I guess I shouldn't say names, but
No, don't. You don't have.
Really nice. And the one really looks out after me when she can. She even knew that my mom was sick. We found my aunt dead in her car like 2 nights ago. And she called, she kept calling, she keeps calling me. She said, there's a envelope outside your door. She goes, do you want me to collect it? It's for the recertification for. She's called my mom and she wanted to make sure my mom was okay. My mom's just a wreck right now. I want to spend the last couple nights with her.
Okay.
It's just bad. It's just one thing bad after the next thing or the next. And it's I know I can't look at everything as bad. I'm not a victim. It's just, and that's where CMH helps. That's where he helps. Talk to school children. And I think I'm a smart guy. I went to school and because of the health diagnosis, they just sent me to the serum. I can't. There's nothing I can do to change that. But that always happened.
All right. Okay, Mr. Thompson, who could put together for us a list of what you're doing right now for the plaintiff's consideration?
Probably Amy or Shad at CMH. Amy's that you don't know.
Okay, because I didn't, although you've been here, I didn't know that you were in the men's trauma group. Or it for whatever reason, it may not have quite come up. I didn't realize you were doing that. I didn't realize all of your involvement with CMH and the like. And so before, I guess, do anything, what I'd like to have is, I want to know what you're doing so that they can know what you're doing. So that if there's a possibility of an agreement, those things part of that agreement may be those things have to continue.
Yeah, it's helpful.
You see what I'm getting at?
Yeah.
Okay, so how How soon can you get a list of what your?
I could talk to Shan today.
Okay, let's do this. Let me do it this way. Okay. Because I think once you leave here, you say the things, but I don't know that it happens like it should. And that may not be your fault at all. Okay. Can you get through to Amy now if you had to?
Yeah.
And tell her what I'm looking for to get to the plaintiffs? You can make a call to her. You have your cell phone with you? Okay, do that. Now, Mr. Thompson, let me ask you another question. This is a hard one. What's your biggest fear with this court proceeding outside of me?
You. I just don't want anybody mad at me. I don't want to lose my home. It was really hard to get it. The psychiatrist always says the same thing. He's like, you have so much potential, you just need the help to get over the hump. And I'm doing that. I mean, I recognize that I'm doing that, but it's scary to know that everything you've worked for. I've been homeless for a long time prior to that. I never thought coming out of school, coming out of college, that I'd ever be that home. Never. I mean, I came from a good family. I can't. People that worked really hard. My dad was a garbage man for 37 years in the city of Detroit. And he was really proud of his son. The last place he saw, he was so excited that I got into the new place at Hableville because then he knew what a hole the other place was. And that's where he died. He died knowing that I was making those conditions. And there was nothing I could do to stop that. But I was so excited when I got to Hableville. And Tasha really helped get me there. So I appreciate it. I've just been through a lot. I really have. And I appreciate you listening.
All right, Mr. Thompson. And there's a reason why I asked that. Okay. Because for right now, and this is one thing I want you to remember. In terms of your losing your home at this point, or those things that as part of this proceeding, people not liking you or whatever, I'm going to tell you this. To the best of my ability, when you're here, no one will disrespect you. But that applies to everybody that's in here. So you don't have to worry. When you're here, you don't have to worry about that. Okay? The other thing, and I want you to, we'll probably have to give another date to get things in place. But in that interim, with regard to your housing, I don't want you worried about that right now either. Okay? I want you to focus on you and trying to get yourself to a certain point. Okay. Now it may turn out that I have to do something. We have to figure something else out. May come down to that. But right now, Mr. Thompson, that's not what you need to worry about. Okay. I tell people this, and I think you know it because you've seen me in court. Nothing is going to happen to you in your housing until I say so. And right now, I haven't said so. Fair?
Yeah.
Okay. All right. Now, why don't you go do this? Go make your call. Let's find, you understand what we're looking for?
Yeah.
Ask her how soon she could put together a list of what you're involved in now.
Okay.
And if she can do it right now and get it over to my staff, then we can get it right to plaintiff so that they can consider it. But I don't want to put a rush on her, but give her a call and see.
I can call too at CMH.
Okay.
See if they can help too.
All right. You understand what we're looking for?
Yeah.
A list of what you're involved in, how often.
Okay.
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 All right. So let me pass the matter. You go make those calls and then I'll call the case back up and we'll see. All right. You're welcome.
Okay, then. Yeah, then that's.
Fantastic. That's a copy
This is a
for
copy for
counsel. For
All right.
court recalls case of Hableville versus Thompson. I don't know. All right. And you got through to Amy, correct? Right. But she got through. She sent us a letter. Did you get a copy of this? We'll make sure to give you a copy also, okay? Of what she sent. So, and I realize, counsel, you guys have just gotten this, but here's what I'd like to do. And what I'm going to do is I'm going to put this over to another day. Let plaintiff consider what's in that letter and whether or not that can be an appropriate framework. Hopefully, maybe we can work out some type or what can be worked out between the parties. What the court would like to see is some probationary type of agreement that he has to follow through on these things. If he doesn't follow through on the things, or if there's another incident, that then he might do it that way. So we could have a conditional dismissal with whatever terms might be satisfactory. All right. You have any other questions, Mr. Thompson? All right. And so how long would it take for you to kind of have that conversation that you guys are going to need to have?
So I'll go back to the regional today. We'll discuss it.
Okay. I have the 20th. Is that right? And the 27th. 20th work? Okay. So I'll adjourn this final settlement conference to January 20th, 2026 at 9. And I would just advise folks that if we can't reach a resolution at that time, then I'll set it for trial. All right? Okay. Thank you. Take care and Happy New Year to you guys. Jerome versus Cassidy.
Extra high if you get.
Well, hold on. Do I have everybody?
Sir Cassidy is in Zoom.
Got it. I got counsel for the parties, Jerome's. I counsel for Jerome's and for the Cassidys.
Yes,
Right.
Your Honor, I'm preparing on behalf of the Jerome's plaintiffs.
Yes. No,
Oh, okay.
really? Boy, I haven't followed that along after the last 30 hearings. I get that.
Okay.
Okay.
I'm new. So
Yes, I do. Well, and that's what I'm saying. I said that's not Lloyd. So I don't know. But I was informed you're representing.
Eric and Villa Cassidy. That's
So
correct.
you're representing both.
I am representing.
Okay, good. So that has all come together.
I don't have anybody for Cambridge.
Just a bundle of sunshine.
A ball.
A ball of sunshine. Okay, I don't have anybody for Cambridge. And trying to recall, is Miss Taupe gonna be here?
I'm checking now, but I don't believe I have any communication from this. And she's normally pretty good about communicating.
It's nice of you to say it that way. So do any of you know with reference to Miss Taupe?
I have not heard from her regarding this particular motion, Your Honor. We did serve her with the motion, and she's been otherwise in communication with me on other matters since yesterday.
I've actually heard from this gentleman.
All right. So is everybody prepared to go ahead with your motion then?
Yes, Your Honor.
Okay, go ahead.
Okay, thank you, Your Honor. The motion before the court is to, the court to obtain, concurrent jurisdiction over the monetary claim to exceed the court's limit at 25,000. Or in the alternative, that the damage claim for current paid rent be removed to circuit court. At the time of filing of the motion, it was all parties and it was all parties in count through counsel's preference that this court keep jurisdiction to hear the monetary claim, given the long history of this case and the court's intimate familiarity with what's going on and how we got here. And it was thought amongst counsel that it was judicially prudent to keep it here instead of starting over in circuit court with the new judge. And so and the court had expressed in the past its willingness or openness to doing so. So I filed a motion to bring that to a head so we can move on. The parties have spent an inordinate amount of time trying to settle this case. It's not happened, and we're ready to move forward with ultimately what is a rent issue from landlord's perspective. So we'd like the court to obtain jurisdiction if the court is willing, and also to move forward with trial. And I understand new counsel wants to clean up some pleadings, which we could be amenable to as well.
You have a position on this?
Thank you, Your Honor. Go from here, wherever.
Either.
First, I will say I appeared yesterday on behalf of the Cassidys.
Yes.
I'm relatively new to the case. As I see it from the docket, Cassidys have not been able to file a response to this motion. I also know that Ms. Jobe is not here. Frankly, I think it would be helpful if we could continue this motion to just next week. I can file something by the end.
Okay. So you need time to talk it through with your clients, figure out if that strategically is what you may want to do, and then do.
That would be very helpful.
Okay.
And while I'm making that ask, it would be helpful if we could also amend. I know that the clients had filed a request to amend or leave so that they could file their answer to the last amended complaint. It would be helpful if I could also do that by the end of the week.
Well, let's do this. Since what I'm going to do is I'm going to adjourn this. I don't think, yes, this has been going on for a long time, but I'm going to adjourn everything, but I'm going to give you time to to figure out exactly what you want to do. It would be nice if it were a case one could step into and just decide. I think counsel for the plaintiff is correct. I think that everybody was reported to me, got together and decided, yes, we want to kind of go along this path, and they were trying to sure things up. But in fairness, now that Cassidys have one attorney, because I think, if I'm recalling correctly, I think throughout these proceedings, they've had separate attorneys for a number of different reasons. I'm going to give you an opportunity to do that and to clean up the pleadings. Have the two of you communicated with each other?
We just did this morning.
Okay, so extensive conversation.
So
No, that's okay. I think counsel for the plaintiff can give you certainly some background as to where it is, and then you could factor that in as to what you will do. All right. This is the second time I think we have actually technically been here on this motion, and I'd like to resolve it, but I also just want to be fair. So
I appreciate that, Your Honor.
you were going to say something else?
Yes, Your Honor, I understand, fellow counsel just arrived and his requests from his perspective are absolutely reasonable. But Your Honor, it's becoming exceedingly frustrating for the plaintiffs, defendants to now be on their fourth counsel, which has led to a number of delays, late filings. And you're right, this is the second time we've been here on this motion, and we are very anxious to proceed and not continue to spend time and money while the defendants figure it out. And the prior adjournment was on December 2nd.
That's correct.
And it is now January
Well-
6th, and the new appearance from the new attorney was yesterday. There was plenty of time the Cassidys to do the things that they needed to do. I want to place an objection on the record, and
Yeah.
if we're going to give the additional time to have that be the end of the time.
Yeah, it will be. And let me just say this, and I appreciate what you're saying in your objections noted that, but what the court is inclined to do, because we had all talked with the counsel, is do one of two things. If we could get jurisdiction over the whole case through order, then we could do that. But also the court's understanding is I can hear the claims, award the judgment, and then somehow there's a process by which it is then certified in circuit court. So if it exceeded my jurisdiction, you just take that judgment and it's just signed off on by a circuit court judge. There's a process by which it can happen. And on a landlord-tenant matter, particularly. So that is the court's inclination. And I say that not ruling at this time, but I say that for your benefit so that you understand as you have your discussions. That's where I was going to head.
And I appreciate that, Your Honor.
Okay.
I will also note, I know that this was December 2nd. I know that there's been a statement that the Cassidys had a lot of time. I don't want to necessarily put it on the record. I'm happy to approach, and
There are
explain.
issues with Miss Cassidy. Is
Yeah,
that what you're?
there are.
Yes. And I think we're all aware of that. And so I understand that. I mean, in a lot of ways, it was an odd circumstance because there were issues with an attorney who's not here today. We had to get through all of that. Then the Cassidys have two attorneys. That becomes the issue. And then one attorney, and I don't know the reason, I'm not saying it's bad or anything like that, for Mr. Cassidy leaves, but then another attorney appears, kind of, Mr. Lloyd. But Miss Cassidy, then that issue regarding her counsel had to be solved. And I'm not sure how that, I know what I did, but I don't know how that got resolved within the university. So a lot went on. So, and I appreciate it. I understand the time frame. I understand all of that. And this file just keeps getting bigger, and I don't have files this big. So, all right. So we'll do it. So how much, you were saying a week, are you going to be able to?
I mean, I don't want to delay this, inordinately. A week.
They're so,
Fine, if
they're
you're
so
fine.
cute when they're young. No.
Thank you.
No. I can do this tomorrow. Anyway, no, I didn't have to. You can, right?
If it helps, Your Honor, I'm not able to be back in work a week from today, but I could do it 2 weeks from today on the 20th.
Do I have that day?
You actually don't have.
I don't have 1 week, but I have 2.
2 weeks.
Okay. Oh no.
Yeah.
We have our one, and you're not here.
Yes.
Oh. Sounds like a bad day for me, but that's okay. Well, do I have the 27th? No. I do. Okay, so that you guys don't get behind somebody and I have no idea what's going to happen that day. And that Ann won't be here to calm me down if it gets bad. Will the 27th work for you?
Yes.
Yes, sir.
Well, okay. Let's do it that way. So I will adjourn the motion out by the 27th. You're going to get all of your pleadings and everything in order. Why don't you do it in case there needs to be any type of response? Could you do that in, say, 2 weeks?
Yes, sir.
Okay. So get all of that done in 2 weeks. So that way if plaintiff needs to respond, they can.
Perfect.
All right. Fair enough.
So hearing is adjourned until the 27th at 9 AM.
Yes.
And then the revised, any revised pleading would be due on the 20th.
Yes.
Okay, thank you.
And since you're the one causing the problem, can you prepare an order to that effect?
Absolutely.
Since you can do it. All right. Fantastic. All right. Thank you. Thank you, folks. Court calls the case of fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixed Housing 401k Plan.
Aaron Ward, this one way. Rick Ward, on behalf of ourselves.
All right. And we have a number of motions.
Yes, we have 3 pending motions, Your Honor. We have landlords MSD, we have tenants, motion dismiss, and tenants. I've been calling it the omnibus motion because it's actually 3 motions in one.
Okay. And have you, let's start with this notion of the omnibus. I understand what you're saying. Are you guys going to represent yourselves?
Yes, Your Honor.
All right. You know how to respond to a motion.
I would say best I can, yes or no.
All right. I don't know. Did you file,
File a response.
pardon?
I did file a response.
To the motion for summer.
Your Honor, we received that response.
Pardon?
We received the response.
Yeah. Okay. Now I see it. It's just, got it. Okay. What motion do we want to start with?
Wherever you'd like, Your Honor.
I really don't have a preference. It might be, I guess, if I take them in order of how they were filed, but I mean, whatever. What was your?
I mean, selfishly, I would like to discuss my motion first. I think it takes away a lot of their arguments.
And let's go there.
Oh, that's fine. I agree.
Go. What?
Oh, I just said I agree.
Okay. Go ahead.
Your Honor, we have landlord's motion for summary disposition. I believe the briefing, like the lease language itself, is clear. The lease expressly provides that tenants must pay monthly base rent of $5,500 without any deduction or set off whatsoever. As this court acknowledged at the November 7th hearing, which we attached the transcript as exhibit E, the court correctly stated this lease language is not conditional. Tenants in their response completely ignore that lease language regarding the rent payment. Your Honor, going to the reply, the response, their sole defense is that this is a residential lease. I believe the argument is meritless. I don't like throwing this word around, but I believe it's also frivolous. Tenants admit in their filings, this court and the circuit court, that they're operating a commercial horse farm on the property Willow Ward Equestrian. Tenants don't reside on the property and is a business collecting money from boarders boarding their horses at the farm. I'm going to read paragraph 2 from the circuit court complaint. Erica Ward leases the property to conduct her business, Willow Ward Equestrian LLC, allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility. And then it continues. Your Honor, again, at the November 7th hearing, you acknowledged the commercial nature of this lease. It's a 7-year lease term that ends April 30th, 2028. Your Honor, you've read more leases than I have, but I have never seen a 7-year residential lease, personally. Paragraphs 4 and 8B also support that it's a commercial lease. I'd also like to highlight in the circuit court, tenants individually are bringing a business interruption.
Can I just stop it for a moment?
Yeah, yes, sir.
Are you really arguing that this is not a commercial lease?
Yes, I'll be arguing that it's a residential lease and the tenant, the landlord the entire time acted in harmony with us in residential lease premises.
Okay, but You guys aren't residing there.
We're not, no.
So what human being is residing there on those premises that could make this a residential lease?
The property, it's a little bit unique. The property includes an apartment with a furnace. Right, that's the observation. The when we received the lease from the plaintiff, I mean, obviously I'm not
Let me ask you this. Do you know what a residential lease means?
from the residential lease, I believe the onus of repairs are different, there are tax provisions are different.
Well,
Lease.
customarily, yes. But maybe you need to understand that a residential lease can change, even if, let's say you're successful in the argument, which quite frankly, I'm having a problem seeing that it's a residential lease. Even if it were a residential lease for a period longer than a year, the parties can change the requirement of who has to repair. So basically what that would mean is this. Even if it's a residential lease for a longer period than a year, the term that you're complaining about wouldn't matter. The term is where the term is. That term could be in a residential lease, provided the residential lease is for longer than a year.
Sure.
Put another way,
Right.
the obligation to repair can be changed if the lease is longer than a year.
We have to be notified that the obligation to repair in the lease was changed.
Pardon?
Where the plaintiff have to notify us that the obligation to repair was changed.
It wouldn't be changed. It's just,
Because section 6 does state that the landlord should make all necessary repairs and replacements to the property in common areas, including heating, air conditioning, electrical systems.
that's fine. The problem is you can't withhold. I mean, I'll let you make your argument. I just don't think it's going to get you anywhere. But go ahead, counsel.
Your Honor, I would, oh, I'm sorry, did you want me to continue?
Yeah, go ahead.
Your Honor, the parties also signed in addition to the lease, a guarantee, a separate guarantee agreement, which also evidences that this case is commercial in nature. Tenants made a good point in the lease also in our favor that the lease does not contain the normal plate statutorily required notices to a residential tenant. Again, this evidences that this is not residential in nature. Your Honor, even if they're trying to transform a commercial lease into a residential lease and are, impermissibly subletting or allowing someone to live on the property, that alone is grounds for default and termination of the lease. So if that's what they're arguing, that works in our favor because that is a separate ground for termination. Your Honor, the case law is clear that tenants may not withhold rent for repairs in a commercial context. I've cited these cases many times to you. They're cited in the brief and also attached. The unpublished opinion is also attached to the brief. I would continue that tenants are responsible for the actions of their former counsel in withholding rent. I should highlight, just for the record and any subsequent, proceedings, Ms. Tope did file an affidavit attached to the response, Exhibit 4, that it appears to have just copied and pasted large portions of Mr. Ward's affidavit. It talks about how she signed the lease and how she works at Mr. Ward's employer. So I would just like to highlight that for the court. That was in response to our MSD.
Thank you. before I have you, who represents you guys in the circuit court matter?
Our attorney, Ms. Tope.
You realize that in these two proceedings, whether the representation is made by you or whether it's being made by your attorney, that you can't make inconsistent representations. You realize you can't do that. Huh?
He did not represent us in our other case.
No, that is not here yet. But you, maybe I shouldn't use the word representation in this. You can't say one thing in one case
Correct.
and another thing in another case.
Understood.
So I'm to understand, and while you guys may not have said it yourselves, but have said it through an attorney, as I'm to understand and what I see, your attorney, Ms. Tope, has made the representation in a circuit court matter that this is a commercial property.
That I'm not going to disagree with you.
Okay.
I don't know.
Now,
Not.
pardon?
I don't know if she's made that.
But you, okay, folks, this is where this
I
is.
agree.
Listen, this is where the problem comes in with you not being represented by counsel. Because if you're going to, and I'm going to give you one break or as many breaks as I think are appropriate, but if you persist in it, there's going to be problems. Because if the representation has been made that it's commercial property there, and then you're left to argue before me that this is a residential lease, that's going to be a problem. A sanctionable problem. Because I almost have to believe that if you're arguing that, you're arguing that in bad faith. I'll put it another way. If you two were attorneys and you came and you know in another action that you're making an inconsistent argument, and I'm not saying inconsistent arguments can't happen, but if in one proceeding you're characterizing something one way, and then in another proceeding characterizing it a different way, if there were a single counsel doing that, I would have very little tolerance for that. And I would be sanctioning. Meaning every time that representation is made to me, you're going to either have to pay the court or you may have to pay attorney fees to the other side.
I understand.
Hold on a second. Do you realize that's where you guys may be headed?
Yes, based on your statements, your judge, I have no reason to not realize that. Yes. The only way I can realistically do is talk to Ms. Tope and say to verify. She's the attorney who followed her guidance the entire time. But I 100% answer everything.
Folks. She's out of this.
Correct. Yes.
You're now before me arguing this case. I won't be sanctioning her. I will be sanctioning you. Because when it comes out of your mouth, you're stuck.
And your advice is what, Your Honor?
I don't really have advice. Look, folks.
So in this case, Your Honor,
my arbor, of course, was to comment on the residential aspect of the lease. That's what that's why I was planning.
So
I'm not going to say
here's what here's where I have to stop you, because there's been documents filed on your behalf in a different court, albeit you're represented by an attorney. They're really your statements, right? Saying something different than the two of you right now are going to say, I anticipate are going to say to me, okay? I'm doing my, I don't want to yell at you guys. I don't want to sanction you. I really don't. I can tell you right now that if you had the same attorney was doing that in two different courts, and I was aware of that, I rarely lose my mind and go off. Well, I probably do it more than I should. But anyway, I would be going crazy. And I would be holding their feet to the fire and making them explain in detail to me how they can have these inconsistent positions. Because here becomes the problem, folks. If you're making that representation, you're probably doing one of the most serious things that a person should not do to a court. And that is that you're misrepresenting facts to me, or you're just out and out lying to me.
I am doing neither, Your Honor. I did not realize that she represented us in the other court in a commercial matter. First I'd heard, so it never were shown before a judge, and I understand what you're saying, but I did not realize that. I read this statement. I'm not obviously an attorney, but I did not see that she had done that. Of course, I would not represent the case two different ways, two different lawsuits, and I'm not an attorney to begin with.
Yeah, but you understand the predicament you're in right now.
Oh, I do. You made a quick
Because if you start that argument, and if you guys want to represent yourselves, I'm going to hold you as accountable as I would an attorney.
Is it possible for us, knowing this, because obviously we don't have an attorney, to get an attorney at this point, or is that not possible?
You can always get an attorney. Sometimes you can walk out in that hallway, throw a stone, and you'll hit one.
Why not?
You can always have an attorney. But I don't know how many times I've adjourned it for. Well, I've adjourned it a number of times. Tried to give you caution about your representation. And then gave you an opportunity for you guys to make your own decision about how you were going to proceed. Well, let me ask you this, just stepping aside from the motion. Why don't you have an attorney?
I believe the Harbor said the whole time.
Pardon?
I couldn't see a possible way we did anything wrong. Of the case we're talking about, of the water heater, of the gas leak, and trying to protect people, I didn't see as possible we've done anything wrong. We've done. You have people living in a place, there's a gas leak, I'm just trying to protect them. The hot water heater sits 5 people or someone sleeps. So replacing it in a process established. We've done this before. We had it fixed, paid, took my out lease. It's the same process. I could not see a scenario where me trying to get something fixed to protect a person from a gas leak was wrong. I couldn't. We done it before where we've taken my out lease to fix other repairs. Like,
Folks,
that's why I didn't get it right.
but if you're renting that property,
Not renting to anybody.
somebody's just there.
They're there for free. My daughter stayed the night there. My wife stayed the night there. the warden to stay there. But the hot water tank sits within 5 feet of an observation room. And I could smell gas, and I just wanted it fixed. So dangerous. I don't know. I didn't think I did anything wrong.
Here's what you need to understand. And this is where it gets kind of weird, but just based upon the scenario you've given me, whether you're charging them or not, you would effectively be subletting.
Just friends with the people living there. He's stored his deer head in the place.
I hear you, but if they're not, you can't do both. You can't analogize this to a residential circumstance because you're creating a residential thing and then not claiming that they're really subletters or akin to subletters. I mean, you're going to have a problem. Folks, you're going to have a problem. Now, if you truly believe that this is residential, then first of all, I think you're going to have a problem and you're going to subject yourself to sanctions. But if you in your heart and your analysis believe that this is residential premises, then that means somebody on your behalf in circuit court has not told the circuit court the truth.
I see the problem.
And then you're going to be subject to sanctions. And folks, when you filed these documents, or even if they're filed, you realize that you're representing that the information contained in there is true.
Mm-hmm. It is. I do realize that.
And do you realize that if I find that it's not true, what I can do?
Mm-hmm.
I don't think you understand.
No, I don't know what the sanctions would mean. I've tried to do things the right way.
You've risen. What do you want to say?
Your Honor, I was just going to say they already rang the bell by filing this response with both of their affidavits, with Ms. Tope's affidavit. I'm not recalling if one of the other boarders also is averring to whether it's a residential lease. But I'm saying they've already rang the bell on sanctions.
I know.
And the sole defense to our MSD is that it's a residential lease. Whereas in the circuit court, they're also bringing a business tortious interference claim and seeking lost profit damages for their business. So that's where we're at.
Want to say anything else?
No, Your Honors. Obviously, another court filing against my attorney.
Pardon?
In the other case, obviously filing against my attorney. I'm not going to say anything that would get myself sanctioned. I just try.
Well, you already have.
Well, I realize that.
That's the problem, folks.
Yep. Any further help with that?
And Mr. Ward, I realize you're speaking. Mr. Ward, is there anything you want to say to me?
I'm comfortable with her representing me.
Do something a little bit unusual. I will rule on this motion today. I'm going to talk to the parties separately, unless there's a strenuous objection from either side.
No.
Any objection? Could you put them into my the jury deliberation? We can go off the record.
Jalen Gaddy, Jalen Avery Tyler Gaddy, 25 T645675C. I need the probation officer to write whether or not the defendant did everything in that one.
Good morning, Your Honor. Good morning, Your Honor. Good morning. 378-413 with MIDC representing Mr. Gaddy.
Good,
Raymond.
good morning. Your name, sir?
Jalen Gaddy.
All right, so this is the driving on a suspended. Does he stand mute, waive formal rating?
Yes, sir.
Where in the world has he been? Fighting in a war? What's he been doing? Where you been?
I just got a new job.
No. I didn't ask you where you work, how much you're making, when you got I want to know why you weren't here 10 months ago, 8 months ago.
Oh, I wasn't aware of that I had to be there.
The officer give you the ticket?
Say that one more time?
Did the officer give you the ticket? It said appear within 10 days, right? Right?
If it did, I missed that one.
You thought the court was just gonna invite you and then you didn't show up. Your address, you live on Graydale, right?
Right.
Well, we sent notices there. You don't read your mail?
That's my.
Well, then just be honest with me and tell me, Judge, I blew you guys off for 9 months. I thought I was larger than life. Don't start standing there lying to me that you didn't know you were supposed to be here, okay? I hate that. Listen, don't interrupt me. Don't interrupt me. Okay, we're not sending out parties invitations here. You know what I'm saying? We didn't invite you to a party. You don't have to go to a party. You don't have to do anything, but you do have to show up in court or there are consequences. We understand one another? Where does he work?
Your Honor, he's working at a florist right now. He's been there for a couple of months. Prior to that, he was at a logistics company. Had been there for a couple of years.
You got $100 with you?
Yes.
$100 cash bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. Let me let you in on another secret. You are not going to endear yourself to these judges in these other courts when you blow them off too. You got 3 out of 36, 2 out of 35th. You got 5 other warrants. Okay? Unless you're hell-bent on going to jail, in which case you keep doing what you're doing, you're going to end up there. I'd go over to those courts and I would surrender today, not tomorrow, today. Do you understand me?
Yes.
Good. Give me a pretrial date if you would, Lisa, please.
I think we put it on the front.
Okay, I'm sorry. You did January 15th at 10. So
Your
without,
Honor, I believe you had a conflict on that date. Can we do the 21st? I'm here back on the 21st.
who has a conflict?
My client.
What kind of conflict does he have?
I believe it's work related.
What kind of conflict you got?
You have to work that day, the 15th? Correct.
You show up 8 months later and you want me to make accommodations for you. Who's this with you? Is this girl with you?
Sister.
I could tell she knows what I'm talking about. She thinks you. What, you got to work, so you want me to reschedule it?
If you met.
I can't do it on the 20. Do we have the 21st when we can do it, Lisa? We don't have the 21st, do we? This is Trent.
No, it would be the 29th.
Still work it out. We'll do the.
I can do the 29th for you. I'll be more fair with you than you have been with us. How's that? You want me to do the 29th or the 15th? It's up to you. But Trent's only here on Thursdays.
I have a conflict, Your Honor, on the 29th. We have to do the 15th.
15, that's fine.
Okay, 15th at 9 a.m. You're gonna have to
Judge.
fill out what?
Did Mr. Granada say he has a conflict?
Yeah, I don't know what.
He's just the arraignment attorney. He doesn't follow these cases.
Oh, yeah, you're just, I thought so. So you don't have to worry about that. Do you want to do the 15th or the 29th?
15.
Are you sure? 15th at 9, go down the hall, post your bond. Don't be doing this again. I'm telling you, I'd go over to those other courts. Those warrants have been outstanding for quite a while. We understand? Yes?
Are you saying I have warrants now?
5 of them. Yeah. Why do you think I'm talking to you like this? Plus, you blew us off for 8 months. Stop, and don't come back with chewing gum either. Okay? We're not in a candy shop. Go down the hall, get your notice. Good luck. And you're gonna have to fill out a petition for a court-appointed lawyer if that's what you want going forward, all right?
Yes.
Good luck. Boy, this is a mess today. What do you
Video for
guys-
Jack Young.
That's my case, Your Honor.
Who is it?
Jack Young.
Jack Lee Young.
People against Jack Lee Young, 119-634-292A.
Morning, Your Honor. Peter Granata, P78413 with MIDC representing Mr. Young for our remaining purpose.
Sir, your name?
Jack Young III.
Detective, your name?
Detective Corporal Sean Pontiac, Trenton Police Department.
So I've got contempt charges here. I hope, Mr. Young, can I ask you a question? How old are you?
I'll be 45, Your Honor. Well, I'm 45. 45.
Why would you do this? Why would you act like a fugitive on a drivewall suspend charge?
Your Honor, he was, he was incarcerated
For how long?
most of 2024 and most of 2025.
Well, he was supposed to be here in 21 and starting to take care of this in March of 21, so that's not an excuse. He should have taken care of it in 21. If somehow, some way he was in the hospital for 10 months, he could have come in and taken care of it in 22. If somehow, some way, something tragic happened in 22, he should have been here in 23. You got a big problem with me. And by the way, you can tell, well, I just don't understand this. Warrants all over the place on this guy. I don't even know what I have here. It's going to take me a minute to decipher this. I got all kinds of files in here. I got two, I don't even know what in the world. I got
It looks like they're both for non-payment.
I got 23B143198. It looks like on that case he owes 129. And on the other one, on the misdemeanor,
He owes 644 on that one.
he owes 644. All right, so how's he going to proceed on these?
Your Honor, I believe that, he's prepared to make a payment today.
Well, I know, but is he gonna plead guilty to failure to pay 644, and is he gonna plead guilty to failure to pay 129, or does he want to have a contested hearing?
No, there is no contest. No.
If you plead guilty to failure to pay 644, you could get 93 days. Do you understand that?
Yes, sir.
Talk to me. If you plead guilty
Yes,
to failure
sir.
to pay $129, you could get 13 days on that, 1 day for every $10 owed. Do you understand that?
Yes, sir, Your Honor.
You have the right to a contested hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. You remain silent, that silence would not be held against you. Do you understand that?
I do, Your Honor.
If you plead
Yes, sir.
guilty, you're giving up all those rights. We're not going to have a hearing, and I will then sentence you on these charges. Do you understand that?
Yes, sir, Your Honor. Is that okay if I talk to my lawyer again about this, Your Honor?
We want to wear the 664, 644.
Well, he's got a big problem. He sees this happening. I'll let you talk to your lawyer again.
I think we want to try to work out something that he could be released today. And
I'm not going to release him. This guy's been playing with us for 4 years. I don't know who he thinks he is.
we could try to work.
Your Honor,
something out.
I've been taking care of my life, Your Honor. I've been on drug court for almost a year.
Listen. Talk to the
Yes,
guy
sir.
in the carnival if you want. I don't want to hear it.
Yes, sir,
You
Your
got
Honor.
warrants all over. You are disrespectful. You have no respect for the system. You think you can just treat the system like some pet of yours, and it's not a pet of yours. We're not a pet of yours. So to shake your head all you want, I can only go by what I see. And what I see is warrants that have been going back and forth since 21, and you've been given plenty of chances. So don't talk to me about releasing you today. It's not happening unless you have the money to pay this. I'm telling you. So you guys can talk again, and we'll go from there.
Okay.
You be brief, Your Honor.
Yeah, no problem. Take your time. Lee Young, the third, 23B143198. And I need to find the other file. And I have 119-634-292A. Mr. Young, your name?
Jack Young III, Your Honor.
Your Honor, I spoke to my client.
I need your appearance
Oh,
again.
I'm sorry, Peter Granada, P78413, MIDC counsel for Mr. Young. Your Honor, I spoke to Mr. Young and he has, he understands and is going to plead guilty to both counts.
So if you plead guilty on the civil infraction, that's 3198, you could get 13 days. You can satisfy that in full by payment, in full by serving a jail term, or in part by payment and in part by serving the jail term. Do you understand that?
I do, Your Honor.
And again, if you plead on the failure to pay 644 on the misdemeanor, you could get 93 days. Do you understand that?
Yes, sir, Your Honor.
And you understand the rights that I covered. You're presumed innocent. You have the right to a hearing. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up
Yes,
all
sir.
those rights, and there will not be a hearing or a trial of any kind. Do you understand that? Do you understand that? I can't hear
Yes,
you.
sir, Your Honor.
All right.
I'm sorry.
so
Yes, sir, Your Honor.
is the civil infraction charge, failure to pay on that one, $129. How do you plead?
Guilty, Your Honor.
Did you fail to pay on that?
I did, Your Honor.
Anybody force you to plead guilty?
No, sir, Your Honor.
On the misdemeanor charge where I sentenced you back in 21 on a 2019 case, to that failure to pay 644, which has just been late fees and default fees and warrant fees and the like, how do you plead to that?
I plead guilty, Your Honor.
Did you fail to pay on that file?
Yes, sir, I did, Your Honor.
Anybody force you to plead guilty to either one of these counts?
No, sir.
Pleas are
No, sir.
accepted. I find the pleas have been made voluntarily and understandingly and are accurate. I don't know what happened with the Lynette Berry's file. Would you make sure it's not down there, Jan? I don't know. I don't know what to say. Counsel, I mean, he's given me no choice. I have no choice here unless I'm prepared to just let somebody do this for the next 22 years. He's been blowing us off left and right.
Your Honor, he understands that he's going to be in custody until he comes up with the amount. He says he should have the amount within the next few days, at the most a week. And so he's going to go to friends and families and try to collect it all up so that he can get released. And then anytime he's served between now and then, be credited against that.
When was he taken into custody, Detective? Can you tell me?
I believe it was just this morning.
Why do you do this? I mean, are you in the habit of doing this? Let me check you have to be. You haven't just
You're,
pointed out the 30.
Yeah.
Hang on.
I got my.
Hang
I- my
on.
life is
Hang
in
on.
this.
Hang on.
Go ahead.
Let me just check
Yes, sir, I
something.
apologize.
You
Yes, sir.
haven't been just singling us out to thumb your nose at. You've got other warrants. Your criminal history is thick. I mean, you've been getting, and when you going to grow up? I mean, you've been getting in trouble since you were in 2001 and you are 44 or 5 now.
You're right. Yes, sir, Your Honor.
So this has just been a consistent pattern of you just disregarding laws and
I had
I mean,
I had an awakening up last year when I went to jail for a year. I've been trying to get my life together, Your Honor. I haven't been in no more trouble since then. I've turned my life around to God, and I've just been trying to make sure. I've been trying to right my wrongs, Your Honor, and it's just been so hard to do all. It's easy to get into this, and it's been very hard to change, and it's just been a slow process, Your Honor. But I am striving to be a great person and not be disrespectful.
Your Honor, I would like to add that Mr. Young is released. I'm going to work with him to get his iChat so he understands where his warrants are, so we can try to get all of those resolved.
Lisa, you remember that language I gave you a long time ago? I haven't done that, used that in a while. Defendant to be given $10 credit for each day served.
Yes, I think I still have that somewhere.
Hey, your record's bad.
I do have it, Judge. You want me to read it to you?
Yeah.
If each day served shall reduce the cost by $30, any payments made by defendant shall further reduce the time required to be served by 1 day for each 30.
Okay, so it's actually on these civil infractions, it should be 10, I believe. So we're gonna make that $10 instead of 30, okay?
Okay.
So that's what I'm gonna sentence you to. You pay 129 or serve 13 days, you're to be given $10 credit for each day served. So if you served 5 days and you only owed 79 and you paid that, you'd be released in terms of this file. Do you understand that?
Yes, sir, Your Honor.
Now, the other case, I mean, look, I feel bad about this, but you've given me no choice. You really have. You were told by Judge Hessen to pay 200 a month back in December of 21, and you kept coming in custody and everybody was giving you breaks.
I went
You
to
pay
jail,
six-
Your Honor.
You pay 640. Listen, I heard what your lawyer said. Were you in jail in 21?
Not in 21. No, sir. Yeah, no, no.
All right. So
no.
what does you being in
No, sir.
jail in 24 and part of 23 have to do with the fact that you didn't do
Okay.
what you were supposed to
I'm
do in
I
21?
apologize, Your Honor. I should have listened. I apologize. I totally apologize. I'm sorry.
On this case, I'm going to take into account any credit for credit that you might have had for these other arrests, and I'm going to reduce this all the way to 25 days. So you're either going to pay 645 or serve 25 days on that one. So if somehow, some way, you can come up with 760, let's see, that was 129, $773, you're going to be released immediately. Okay? If you don't, then you're going to have to serve the 25 days. Lisa, those are running concurrent, okay? They will run concurrent. So they're not going to run consecutive, they will run concurrent. I really hope you grow up and change your life. This is kind of distressing to see as an outsider what you're doing to yourself. I mean, they only give us one of these things.
You've
You
seen
know
me
what I
my whole
mean?
life and my family, Mr. McNally, and I apologize to you, and I'm turning around. I promise you won't see me again. You
I
will not
wish you
see me
well.
no more.
I wish
Thank
you well.
thank you, Mr.
I really
McNally.
do. Good
Thank you. I
luck.
appreciate that.
Thank you.
sir.
Okay,
If I can.
Gabrielle Christine
Thank you.
Popovski. 25W8381888. Good morning.
Good morning, Your Honor. Joe with Hinsdale, Mr. Popovski, this is Mr. Stino's matter.
Casino 253, Jen. All right. Your name, ma'am?
Gabrielle Popovski.
All right, so she has a charge here of failure to refrain from consuming alcohol, being arrested on September 4 of 25. What is she going to do?
Judge, I think the violation was picking up a new offense.
It is.
She pled guilty to 2 other counts the last time we were here. We put this one on hold. She still hasn't been charged on that case, although my understanding is Mr. the blood draw is met. So what I'm hoping to do is to adjourn this one more time.
She pled guilty to 2 other counts?
Yes. And she was sentenced to IOP. The adjustment maybe it's over.
I'm lost. Your name?
Lisa Tino. You sentenced her on the first 2 counts, but
Wait a minute. I only have one blueback here. And that's the failure to refrain from consuming alcohol, being arrested for OUIL on September 24, 25. That's the only one I have. I don't know why this is happening more and more lately. I just don't understand why this is happening. Can you fix this for me, please? Get the other blue back, and then I'll recall the case, if you will, please. Thanks. Which one?
that's the one.
Popovski?
Yeah.
Gabrielle Christine Popovski, 25W8381888. All right, so maybe I misunderstood Mr.
It is confusing because I included.
Your parents, Mr. Haynes.
Who would expect Mr. Popovski?
Okay, your name?
Gabrielle Popovski.
Get that phone out of here.
Oh,
What do I do with it?
Put in your car.
I don't have a car.
Ma'am, just stay right there. Shut the
I'll turn
phone.
it off.
Ma'am, please, please, please. Thank you.
Emily Casino. I was just gonna say, it is confusing. We dealt with the show cause, back in October where I included that she was arrested for the offense. You had me issue it for a separate show cause for the new offense, but she has still not been charged.
What was the show cause I have of October 27th is for being arrested for OUIL.
Correct. You had me issue its own show cause and we adjourned it to today to see the outcome. I ran her record and she still hasn't been formally charged, but I was able to obtain the blood draw results. So I don't really know how you want to proceed.
Okay, but what I've got is she was found guilty on October 27th. Hang on. Up there to submit to chemical testing October 14th. Count one was dismissed on motion of the probation officer. So then I took that, it looks like, and ordered additional cost of $100, attend outpatient treatment or IOP as determined by the therapist, serve a day on the court work, and pay $35 for that. And then to remain on a sober link and test once a week. So all I've got outstanding then is this charge. She's not been charged, right?
She is not charged, but I do have the blood draw results. So I don't know if you want.
For the results.
0.333.
Why what they're waiting for? What department is this?
It's Van Buren. I called over there today and yeah, they were able to provide me the blood draw results. It looks like they've had them since October 15th, but I looked it up. There's no court date scheduled and it doesn't even show up on her criminal history. It just has the permit on her driving record, no charge either.
Okay, so but do you have the show cause of October 17th?
So I have it.
Let me see that. That's the problem. I didn't have that one. All right. Why did I write down not guilty plea as to count 3? I can't figure this out. There is no count 3. Or unless I assumed that, look, she should be charged with failure to refrain from consuming alcohol on the offense date.
Yeah, that's what I did. No, I literally just got the blood draw results today. So
I understand.
I-
So that's what I'm doing. She's gonna she's gonna type up a new charge of failure to refrain from consuming alcohol. And I'm gonna have a hearing and I can rely on hearsay for her to establish that she consumed alcohol.
We haven't even had a chance to discuss how she's pleading.
No. I'm not suggesting we move right now. She's gonna do the new one. And you're going to talk to the defendant and see how you wish to proceed, okay? And I don't care how long it takes us today. I'm gonna hand you these back. I think count 3.
It's weird because I think it's technically count 1 because it's considered a technical, not a non, you know what I mean?
Yeah.
So I think people have just added.
It's a non-technical instead of a technical. I get it.
Yeah.
All right, so just bear with us and we'll be back with you, okay? Thank you. Gabriel Christine Popovski, 25W388188.
Early days, was Popovski.
Ma'am, your name? So the charge is she failed to refrain from consuming alcohol. And it's obviously commensurate with an arrest, and they think that she had a 0.333 on her results. How is she going to proceed here?
She hasn't been charged yet, but I'd anticipate she likely will be. I would ask the court to accept no contest plea.
That's fine. I'll be happy to do that. So is the no contest plea going to be to violation of law, or is it going to be to failure to refrain from consuming alcohol? Ma'am, if you plead no contest, it has the same effect as a guilty plea. Do you understand that?
Yes.
If you plead no contest to this charge, I could revoke your probation. That'd be a non-technical violation. And you could be incarcerated for up to 90 days. Do you understand that? And did you sign, read, and understand the advice or rights form here today? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
And you understand all your rights, correct?
Yeah.
To the charge that you violated a law, and you understand again, I want to just cover this. I don't want you to feel uncomfortable. You understand that if you plead no contest, again, it has the same effect as a guilty plea.
Yeah.
All right, to the charge that you violated a law on September 24 of 25. How do you plead? No contest?
Yes. That's fine.
All right, and I can refer to a report. You stipulate that there's a factual basis for this. Are you on probation or parole right now, besides to me?
No.
Anybody force you to plead no contest? All right, I'm gonna accept your plea of no contest to violating the law, being convicted of, or at least not being convicted, but committing the offense. No contest plea to OUIL. How I'm concerned about this.
If I may, because we took a plea on 2 other matters, I guess it's probably a couple months ago.
Right.
And in the interim, I think things have been going relatively well, so we've got this very high BLC, that's a bad,
Shanna Soberling,
yes. And
you haven't violated?
Didn't you put me on it when you found out?
I know, but you haven't blown positive, you,
Been driving once a week too. And blowing.
let me do this. I need to take a recess. My staff needs to take a recess. Give me 5 minutes. I'll get Ms. Tessino out here, and I don't know what happened with the, okay, so just give me 5 minutes. Okay? John, where is Lynette Johnson's file?
Give that.
Let's do Popovski. Emily. Gabrielle Christine Popovski, 25W838818A. All right, counsel.
Thank you, Your Honor, Derwin has been listed possible.
Ma'am, your name?
Ski.
All right, so I told probation that I would like to see a copy of the police report. So I'm going to take a look at the police report with regard to the conviction. I'm troubled by this. I mean, I just put you on probation in July, and this is pretty outrageous. So I don't know what to tell you. What would you like to say in addition? Anything else?
Yes, Judge, because in terms of the other violations, one of the things the court had in mind was that Ms. Popovski clearly needs help and needs to participate in the test of outpatient, which she's done. The testing has been, I think, close to acceptable. I think we thought it may have been a couple of weeks, but all the other tests have been negative. That's a big step for somebody who will a 0.33 in September. So I would ask the court to stick with Ms. Popovski for a while and see if she can continue to engage.
Your name?
Emily Tessino,
Let me see the screening report and the police report.
the new police report.
Yes. I don't remember what kind of record she has.
This was her first confession, the one we have around.
All right. Did you get a chance to look at this police report?
We went over it, Mr. Stephen and I, were definitely.
It was an accident too, eh? Well, you weren't talking too nice to the police. Huh?
Oh.
Here you go, Sadie. All right. What else? Anything else? Anything else?
Yeah, I think all responsibility.
It's bad news when you're in here on a public intox and you go ahead and you get arrested for drunk driving, and I don't want you to talk about that. You got a 333. Pay additional costs of $100, serve 3 days jail right now. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You're gonna remain on the sober link. Did I give her a date on that?
No, it's just the condition of her,
Tenant to be on sober link device. I don't care how we do it, if she turns it in now and then comes here after.
honestly, they'll charge her an enrollment fee if she,
Okay,
so it makes sense for her just to pay, it'll be cheaper for her just to pay the 3 days.
all right, so, yeah, you'll be on a sober link device until March the 1st of 26. So can you pay the $100 down? Pay now. She's in custody for 3 days.
How long throughout the weekly testing to continue?
Yeah. What was she on before?
The initial,
Monthly. What was, weekly testing to continue until May 31. Then bi-weekly. Yeah, that scares me. That's what I'm gonna do. Good luck. Yeah,
if she is convicted, do you want probation to?
no. No. He essentially said this would be he was gonna treat this like a conviction. Okay?
Never.
That it wasn't for failure to consume, failure to refrain from consuming, but it was for a no contest plea to the conviction. So I'm gonna give her a chance, but she's gonna have to get her act together real quick, or you're gonna end up with some dire consequences. Good luck. Have a seat over there. Thank you. Thanks, Ms. Raines. Timothy Wayne Shelton, 25B705118. Give me just once. All right.
Governor James Anderson, P31302 on behalf.
Oh, boy, you're one of the old timers like me, huh? Your name?
Timothy Shelton.
Your name? Are you on this, Ms. Holloway? No. Where's the prosecutor?
Amelia?
Yeah. Do you have to, you don't have to stay here.
Judge, I have one matter that Aaron Fleischer wants to go on the record regarding bond. That was my understanding, Judge. He's still,
I was just saying, I wouldn't mind.
well, I apologize, Councilman. I'm not trying to step on your toes.
No,
I'm not changing my mind on the bond. If you feel like you have to do it and he's still out there, Lisa, bring him in. I don't have a problem, but I'm gonna need.
He logged off.
Okay, then, Judge, since he's got other issues to deal with, I don't have a problem in adjourning this matter. When can we, is it next week or?
Didn't we set up that already?
Yeah, we set it for a final pretrial next week and a competency.
I
Yeah.
want to make sure.
So, and that's gonna be in front of Judge Hessen. It goes to her, but we're gonna prepare the order for competency.
Okay, thank you so much.
Thank
Everyone
you.
have a good day.
Hey, you too. Thanks for your help.
No, thank you.
All right, counsel, your appearance.
Good afternoon, y'all. I'm asking answer on behalf of the people.
Can you spell your full name again for my recorder?
Of course, Amelia is spelled Nataeliela, and my last name is Asmaro.
Okay. All right, thank you. Today's the date scheduled for a preliminary examination. The charge is parental kidnapping. It is alleged that the defendant, Mr. Shelton, did take or retain for more than 24 hours his child, one Sarah Pasalacqua, with the intent to detain or conceal her from her other parent or legal guardian. That's punishable by a year and a day. Any preliminary matters here?
No, Your Honor.
Any preliminary matters, Mr. Anderson?
Your Honor, I think the victim's name, the plaintiff, I think you mentioned Sarah Pasalacqua.
Yeah.
I think that is the mother of the child.
Well, she would be the victim, right? I mean, she's named as the victim in place instead of the child, right?
That's correct.
Okay, so, all right. Any preliminary matters?
No, Your
None.
Any preliminary matters from the defense?
None, Your Honor.
Call your first witness.
Thank you. People call Miss Sarah Pasalacqua. I can't do the last name. Lacqua. And I can spell that. Sarah is Sarah. Last name Passalac. QUA.
Thank you. Ma'am, raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God. Okay, have a seat. Now, I can tell right now you're soft-spoken. I need you to really keep your voice up for me, okay? You can proceed. And no mm-hms or uh-huhs. Nice and loud, like you're talking to people on the other side of the wall there.
Thank you, Your Honor.
Thank you.
And Miss Sarah Passalacqua. Good afternoon. Is it all right if I call you Miss Sarah? Yes. Thank you. And now, Miss Sarah, do you know an individual by the name of Mr. Timothy Shelton? Pardon? How do you know that individual? I share that. Okay. And is there any other relationship with this individual?
We've been together for over 6 years. And we ended our relationship, and together, when our son was 6 months old.
Okay, and who's your son? How old is he today?
He's 14.
Okay. And are you familiar with the address of 22068 Dale Street?
Yes, that's my address.
Okay, is that in the city of Brownstown, County of Wayne?
Yes.
Okay, and I want to draw your attention back to the date around Christmas time, about December 23rd, 2025. Do you recall that time?
Yes, I do.
Okay, did something happen that day that brings us into court?
Nice and loud for me.
December 24th, Timothy and I, agreed that our son would be returned to me, we lived at Christmas Eve.
Wait a minute. Wait. Maybe you're talking loud and I just can't hear like I used to. You got to go a lot louder, like you're talking on the other side of the wall. So Tim, the defendant, and you agreed that he would return your son to you on the 24th
Yeah.
of December.
Yeah.
Okay, now continue nice and loud.
And, I, around 10 something, I messaged my son's phone and said, when we'll be back. And then, Tim responded saying, this is Tim.
And Sarah, let me stop you there, go a little bit farther back. You stated that you guys had an agreement. Is there any sort of order or anything in place between you and Mr. Timothy and this child that you have?
Yes, he has parenting time. He had parenting time. We're gonna pick him up Saturday mornings at 10 a.m. and return him by 8 on Sundays.
And was this an order?
Yes.
And do you recall if it was signed by a judge?
Yes.
Do you know which judge signed it?
It was Judge Pierce.
Okay. And would you recall this order if you saw it here today?
Yes.
Your Honor, may I approach the witness?
Yeah, you can have that marked.
I do not have an exhibit sticker, Your Honor.
We'll give you one. We're gonna mark those. We'll have it marked People's one, okay?
Would you like it marked before meetings?
Yes. And then if it is admitted or either way, you're going to be responsible for holding on to it, okay? So we'll have that marked People's one, and then once she hands it back, you can approach the witness.
Thank you. I did have a huge list of exhibit stickers. Had a bunch of them and I cleaned my bag and no longer have
No worries.
to get some.
I think they cost about a penny a piece. I don't know.
Thank you, Your Honor. And now, Miss Sarah, do you recognize, I'm handing you people's proposed exhibit number 1. Do you recognize what I've just handed you?
Yes, I did.
And could you please tell me what it is?
This is our custody order. It's our up-to-date order for parenting time and for parenting.
Okay, do you recall when this order was in place?
Yes, it was February 2022.
And does it appear to be accurate depiction of the order?
Yes.
And does it appear to be manipulated or altered in any way?
No, it doesn't.
Okay, Your Honor, I'm just kind of moving to this point.
Any objection, Mr. Anderson?
No objection.
People's one is admitted. You can hand that to my recorder unless you're gonna ask questions about that.
Thank you, Your Honor.
You want her to have that document to,
Potentially for refreshing.
okay, go ahead, hand it back if you would, Sadie. You can proceed.
Now, Ms. Sarah, you stated that this order was placed on which date?
It was February 18th, 2022.
Okay, and what did that order state in regards to custody between you and Mr. Timothy?
It said our parenting time for Timothy would be every Saturday at 10 a.m. to Sunday at 8 p.m. with telephone and or virtual parenting time every Monday, Wednesday, and Friday at 6. And, I don't know where it says it, but it also says, other parenting time as parents mutually agree. Says that in here somewhere.
Okay, at any point, did you the times that were allotted by this order?
Yes, on December 20th of 2024, we discussed.
Wait a minute, is this 24 or 25?
It goes into 25, but it was 24 to start.
Okay,
Right? Am I in or am I wrong? I'm sorry, is it? Yes, it was December 20. Yes, summer 2024, and then it changed to 20. Sorry about that. That was. Dark Horse. So it was the end of December. Yes.
Okay, and was it just to confirm last Christmas or this past Christmas that just happened?
Christmas before it was passed.
Okay, and now, what occurred?
On the 20th, we both discussed, Timothy and I, that he was going to take them on the 20th and return them on Sunday, the 22nd, and then pick them up again on the 22nd and return them on Christmas Eve evening, so I could have them for Christmas morning.
And did he return him on Christmas Eve evening?
No, we did not.
Okay, and did you try to contact him?
Yes, I did.
And how was it you tried to contact him?
I messaged our son and Noah, and Timothy responded saying, "This is Tim, and you're not getting him back." I've notified authorities and other people, and so we can go to court about it.
Okay, and when was the last time that, when were you able to get your son back?
January 18th.
Okay, and did you file a report about this?
Yes,
Do you recall when you filed the report?
I filed one on the evening of Christmas Eve.
Okay.
Late at night, I wasn't coming back, I went to the police station.
Okay. And do you recall, you stated that you made a police report, and do you recall if this order, this one that you're holding, the order from 2022, was that in place on January 14th of 2025?
Yes,
And when is it that you were able to get your son back?
January 18th, 2025.
Okay. One moment, Your Honor.
I think you misspoke though. You're talking about Christmas Eve of 24, right?
Yes, Your Honor.
And she's talking about January the 14th or 18th of 25 that you got the child back.
January 18th of 25.
So about 50 weeks ago, right?
Yes.
Okay, go ahead.
Nothing further, Your Honor.
Can you, do you recognize Mr. Shelton here?
Yes, I
Can you identify him?
Yes.
Point him out, tell him what he's telling us what he's wearing?
I'm just wearing a checkered shirt, and black shoes, and
All right, what record should reflect that witnesses identified the defendant?
Thank you.
Cross-examine.
Ma'am, you do acknowledge that, there's agreement between you and him that the son was to be returned on the 24th, thereabouts.
Of what month?
The 24.
December of 24?
I'm sorry, can you repeat that?
Okay.
You acknowledge there was an agreement between you and Mr. Shelton that the child, your son, was going to be returned on December 24th of 24.
Yes, sir.
You're also aware that your son had been running away from your home a lot around this time because of allegations of abuse by the man that was in the house with you and yourself.
That happened, he was starting to run away when I got him back after the 18th of January in 2025. The first 2 days that he was home, we ran like 4 times, but nothing before that. We had a great relationship on December 24th of 2024.
You remember being interviewed by the police and talking to the police regarding your son running away from your house?
Yes, I do. They told me to just go to the side.
Do you recall your son saying that he had been physically abused?
Hang on a second. Can you repeat your last question?
Oh, I'm sorry. The question was whether or not that her son had said that he had been physically abused by herself and her partner, Mr. What's his name? Partner.
I said,
I objected to your say so the son said to her.
Any response?
I'll move on here.
Thank you. Sustained. No. Any response to that is strict.
Would it be fair to say then, according to you, that he started running away from home in January once he was ordered to come back to your house, correct?
And Your Honor, I'd object to speculations to why he was running away.
Well, if she knows, she can answer.
How would you know
How does he know except through the knowledge of others? I'll sustain. And which would be imparted to her by hearsay statements.
Did you ever have a conversation regarding your son as to why he left the house or would not come back to the house on Christmas Eve, December 2024?
conversation with whom? What do you mean?
Mr. Shelton, Timothy Shelton.
He text messaged me from her son's phone saying he wasn't returning them.
Did he say why?
Yes, he said he had concerns and he had notified authorities in Brownstown and Adrian where they were staying, and that was false.
No, I'm just asking whether or not he told you that.
He did, but it was just intimidation because he really did it.
Well, ma'am, I didn't ask you that. Let me ask you this then. He also told you then
Your Honor,
that,
I also object to any of the statements that the defendant made that are not part of the policy.
Nice and loud for me.
It's not statements against his interest, Your Honor, so it's hearsay.
True. Right? Sustained.
you got me, Judge?
Yep.
All right,
These young lawyers, you gotta watch out for them.
so, notwithstanding that, is he still staying with you today?
Yes, sir.
And he's 14 years of age?
Yes, sir.
And have you been back to court at all? I'll start with that question. Have you completed the parenting time that you were supposed to cooperate with Mr. Shelton in terms of visitation of your son?
Well, Your Honor, I'd object to references to this specific case.
I only say that because Your Honor, when this was going on, my time was awarded parenting time, where he was able to visit his son, the supervisor, of course. And it's our position that she stopped that.
But this is after the fact, right?
Well,
It's after the incident of December 24 of 24, right?
yes, however, there's still certain court order in effect.
So what is your position? You're gonna show that she violated the order that justifies him violating the order in December of 24?
Well, I just state that it shows that she violated the order. It's an open order as far as I know, it's still in effect.
I'm gonna sustain the objection. I'm sorry.
Ma'am, your son is not receiving any counseling regarding this incident, is he?
Or he, no. Not good.
Thank you. Nothing further.
Redirect? Call your next witness. You can step down, ma'am. All right, people move the bind over.
Yes.
You agree it's a fact question, Mr. Anderson?
I do, Your Honor.
Case is bound over for further proceedings to the Wayne County Circuit Court. 50,000 PR bond. You don't have any objection to continuation of that, do you, counsel?
No objection.
I'm gonna go ahead and continue the bond. 50,000 PR, same terms and conditions. Your AOI date, you being out of custody will be on January the 20th. And that'll be at 9 o'clock in the morning in the Criminal Justice Center. And a bond will remain at 50,000 PR. Same bond conditions. No contact with Sarah Paz Lockwood except to effectuate visitation in accordance with the judge's Third Circuit order through third-party contact supervisor. And the visit to be scheduled through Growth Works. No firearms or dangerous weapons. You cannot leave the state, cannot violate a law. You must appear in court as directed. I wish you well, sir. Good luck to you. Thank you.
Thank you, Your Honor.
Thank you both. And Happy New Year.